Hello and welcome to this episode of the Diary of a Lawyer, and I want to talk about the child detention in Australia. The changes have been labelled as the old darkest hours, quote unquote. Now, the government in Queensland, which is under Palazooks, has reportedly rejected a chorus of criticism over a raft of new laws allowing children to be held in police watch houses, and move that has been condemned as the darkest hours in Queensland politics. The Deputy Premier, Stephen, said amendments to the youth justice laws were difficult, but apparently ultimately essential to ensure community safety. Queensland obviously is part of Australia, which is a federal country, and the amendment follows a pivotal Supreme Court ruling against the Police Commissioner and Youth Justice Department over the lawfulness of holding remanded children in police watch houses rather than in youth detention centres. The ruling led the government to urgently revise the early Act in amendments attached to a child safety bill. Now, we had legal advice that is quoted. The Deputy Premier is quoted as saying that they had legal advice that a recent court case that set a precedent on the basis of a technicality that had invalidated the process used for more than 30 years in Queensland in the circumstances where a young offender has been charged with an offence, but there's no suitable space within a youth detention centre, said Miles to reporters. He goes on to say that they were advised that if they didn't make changes, the young people in watch houses would need to be released to the community. And the government maintained the decision would affect an average of around 40 juveniles held in remote facilities where youth detection was not available. The government has steadfastly continued to draw harsh criticism, however, from the opposition, in particular the Greens and Cater's Australian Party, that the legislation was rushed through Parliament without proper scrutiny. We witnessed perhaps the darkest 24 hours in Queensland Parliament in a long time, the opposition leader David Crisfoley told reporters on Friday. Now, Queenslanders were one listened to, he said, and the entire parliamentary process was used as a doormat by the state government, Mr. Crisfoley said of the amendments. No one wins when that happens. Advocates such as the Queensland Human Rights Council, the Queensland Law Society, and the Queensland Council of Social Service have roundly criticised the changes. And however, the government maintains its position, saying that they are concerned about public safety. I think we have to put in context this the specific region, which has a long history of public known injustice toward Aboriginal children, especially in that area, and systemic issues of racism and injustice, and losses of life in police custody, and generally socio-economic issues which disproportionately affect the Aborigines. And so that's in a nutshell in relation to this topic, and there we shall leave it on this episode of the Diary of a Lawyer, and we shall speak again. Thanks for listening. Bye.